Hi everyone, welcome back. This is the first part of Q&A or problem and solution with respect to Indian Evidence Act 1872. Now the first problem is First Information Report or FIR. Is this an evidence? So here in the section 3 of Evidence Act 1872 is the relevant section, and we have a case law Nisar Ali versus State AIR 1957. Nisar Ali versus State. The first information report FIR is not an evidence. FIR is not a substantive evidence. It can be used to corroborate the information under section 157 of the Indian Evidence Act or to contradict him under section 145 of Indian Evidence Act if the informant is called as a witness at the time of trial. FIR can be used to contradict only the maker of the informant who lodged the FIR under section 145 and section 155 of Indian Evidence Act, but not the other witness. Now the next problem is A is prosecuted for the murder of B. Prosecution produces many witnesses, but all of them became hostile except the police witness. Can the court convict A only on the basis of evidence of persons belonging to police force while the other witnesses are gained over or hostile? Give reasons and also refer to the case, if any, on the point. So here the solution given is, yes, the court can convict A only on the basis of testimony of the police if the testimony is found reliable. Now the next problem, A commits the murder of B. Two police officers are eyewitness of this occurrence. There is no witness except these two police officers. Can court convict the offender A on the basis of the testimony of only police witness? Give reasons and also refer to the case law, if any, on the point. So here the case law is Prithvinath Pandey versus State of UP. Prithvinath Pandey versus State of UP and 1994. A can be convicted only on the evidence of the police officers who are eyewitness of the occurrence. Now the next question is A, an accused, is prosecuted under section 302 of IPC. There is no direct evidence of the offence, but there are circumstantial evidences against A. Can A be convicted only on the ground of circumstantial evidence? If so, when? So the solution, section 3 of the Evidence Act 1872 is relevant here. Now, yes, A can be convicted only on the basis of the circumstantial evidence if all the links of the chain of the circumstance are complete. Now, the next problem, can an evidence obtained by committing the offence of theft be admitted in a case of criminal nature? Give reason. The relevant section here is section 3 of Evidence Act 1872 and the relevant case law is Magraj versus R.K. Birla AIR 1971. Magraj versus R.K. Birla AIR 1971. Such evidence is admissible. So the next problem, in a case the accused A is charged under section 302 IPC for the murder of B. There is no direct evidence regarding the occurrence of the murder, but there is evidence to show that the accused A and the deceased B were seen together just before the murder of B. Should A be convicted on the basis of this circumstantial evidence? Give reasons and also refer to the case law, if any, on the point. Again, section 3 of Indian Evidence Act 1872 is relevant here, and the relevant case law is Lakhanpal versus State AIR 1979. Lakhanpal versus State. No, A must not be convicted on the basis of the given circumstantial evidence. In the case, that is the Lakhanpal versus State, in this case, the Supreme Court held that circumstantial evidence that the accused was seen with the deceased just before the murder of the deceased is not sufficient to warrant a conviction, as the circumstantial evidence present in this case does not by itself lead to an irresistible inference that it is the accused who has murdered the deceased. Now in another case law, that is Mangaleshwari versus State of Bihar AIR 1954. Mangaleshwari versus State of Bihar AIR 1954. In this case, Supreme Court held that in order to warrant a conviction on the basis of circumstantial evidence alone, the court must consider the evidence should not be only consistent with the guilt of the accused, but must also be inconsistent with the innocence of the accused. So that is in Mangaleshwari versus State of Bihar, AIR 1959. So the relevant case laws were Lekhanpal versus State, AIR 1979, and Mangaleshwari versus State of Bihar, AIR 1954. The next problem. Accused N is charged and prosecuted under the Section 302 IPC for the murder of a child aged about 7 years. There was no eyewitness of the murder, but the following circumstantial evidences were proved against the accused N. First one, the deceased was seen going towards the place of the occurrence with the accused 1 hour before the sunset, that is before the occurrence on the day of the occurrence. The second, the accused was seen alone while she was returning back from the place of occurrence. Third, there was a blood spot on the cloth of the accused while she was seen returning from the place of occurrence. Third, the earrings which the deceased was wearing was recovered from the accused. The fifth one, the broken bangles of the accused were found on the place of the occurrence near the body of the deceased. Can N be convicted for the murder of the child on the basis of evidence in the nature of circumstances mentioned above? Give reason and also refer to the case law, if any, on the point. So Section 3 of the Evidence Act 1872 is a relevant section here, and yes, the accused can be convicted on the basis of circumstantial evidence, and you can use the case law Nishastri versus State of Orissa. Nishastri versus State of Orissa, AIR 1954. Here, in this case, the Supreme Court observed that if the circumstantial evidences are considered separately, it does not prove the murder of the deceased by the accused. But if all the circumstances are combined together, it is clear that the murder was committed by accused only and by none else. Now, the next problem. A is accused of B's murder by beating him. At the time of the incident, there was an exchange of words. Now here again Section 3 and 7 of the Indian Evidence Act 1872 is attracted. Now the next problem. A suitor does not bring with him and have in readiness for production at the first hearing of the case a bond on which he relies. But at a subsequent stage of the proceeding, he wants to produce the bond and prove its content. Can he be allowed to do so by the court? Discuss according to the legal provision. So here, the illustration B of Section 5, that is relevant fact. Illustration B of Section 5 of the Evidence Act 1872 is attracted. The suitor in this problem cannot be allowed to produce the bond at the subsequent stage of the proceeding when he does not bring with him and have in readiness for production of it at the first hearing of the case, otherwise than in accordance with the condition prescribed in CPC. Now the next problem. In a trial for dowry murder of B, on the alleged murder night, the police received a distress telephonic call from B, in which before abrupt disconnection she could only say, "Please help me, I fear immediate harm to myself." Is it a res gestae or not? So res gestae is discussed in Section 6 of Evidence Act 1872. The term res gestae is equivalent to the facts mentioned in Section 6. However, it is also used as equivalent to details of facts in issue and fact in issue and surrounding circumstance. Now, Taylor defines it as including everything that may be fairly considered as an incident of the event under consideration. Res gestae are those circumstances which are the instinctive, that is automatic and undersigned incidents of a particular act. They are the acts talking for themselves, not what people say when they talking about the acts. Statements often accompanying physical happenings. The question is to what extent of such statement can be regarded as part of the transaction. For a statement to be relevant fact, it must be contemporaneous with the fact, that is made either during or immediately before or after its occurrence. Thus, A, while running in street, crying that B has stabbed him is a relevant fact, but statement made during the investigation of a crime are not relevant fact. The doctrine of res gestae is applicable to hearsay evidence also, which is not considered a good piece of evidence. Now, in the case of R versus Foster, that is an 1834 case law, the witness had seen only a speeding vehicle but not the accident. The injured person explained him the nature of the accident. He was allowed to give evidence of what the deceased said, although it was only a derived knowledge. It is being a part of res gestae. So here, the telephonic call can be taken as a admissible evidence. And we also have another case law where a lady, while she was having an issue with her husband was beating her, and she made a call to the police and said that please help me, and later she died. So this, she also did a recording, and the recording during the like while the husband and wife was having a quarrel and he was beating her, she made a tape recording, and that recording was made an admissible evidence. Now another problem: A was killed in broad daylight in one of the crowded bazaar of Basti. At the trial, B was examined as witness. She stated that when she reached the spot, she heard the people present saying that C and D had committed the crime. How far the statement of B is admissible in evidence? So here again, it's a case of Doctrine of Res Gestae, Section 6 of the Evidence Act 1872. The remarks made by the person under the eyewitness could only be hearsay because they must have picked up the news from others. The eyewitness spontaneously told the persons reaching the place immediately after the occurrence that the accused killed the deceased. Such persons derived knowledge about the incident spontaneously with the happening from the eyewitness. Their evidence was held to be relevant under Section 6 as forming part of the same transaction. And this was held in Om Singh vs. State 1997. Om Singh vs. State 1997. In this problem, A was killed in broad daylight in one of the crowded bazaar of Basti. At the trial, B, as a witness, stated that when she reached the spot, she heard the people saying that C and D had committed the crime. The statement of B should be admissible in evidence as forming part of the same transaction as the statements of the bystanders shortly before or after the incident is a relevant fact. Now in a case law, that is Nasir Din versus Crown 1944. Nasir Din versus Crown 1944, in which the witness did not state that the people who informed her of the murder by the accused persons were present at the time of the murder. Therefore, on the ratio of this case, since the witness B was not told by the people that they were present when C and D had committed the crime, her statement was not admissible in evidence. So that is the two scenarios where the statement of such a hearsay statement was made admissible, and in a case where it was not made admissible. In the first case, that is Om Singh versus State, it was made admissible because those people who told B about the incident, about the accused, were present when it was a spontaneous act. The people were present at the scene of the crime and it has just taken place, and they told the statement right after the crime took place. And then the second scenario, that is Nasir Din versus Crown, the B was not sure if the people who told her about the crime were present at the scene of the crime, whether they were the direct eyewitness or not. So there it was not made admissible under Section 6. So these are the two scenarios. The first scenario is Om Singh versus State, where such a statement of B was brought under Section 6, and the second one, Nasir Din versus Crown, where the hearsay evidence was not brought under Section 6. Now the next problem. A wife had only seen a fast-running vehicle which had crushed the husband at a little distance. She had not seen the accident herself. The husband died of a heart attack a day later. Can wife's evidence be taken of what the injured husband said to her after the accident? So this is illustration A of Section 6, that is res gestae. Now the facts of the problem is based on R versus Foster. That is an important landmark case here. That is 1834 R versus Foster. In this case, the deceased was killed in an accident by a speeding truck. The witness had only seen the speeding vehicle towards the deceased and not the actual accident, his view being blocked by the another vehicle coming from the opposite direction. Immediately after the accident, the witness went to the deceased and he explained to him the nature of the accident. In this problem, a wife saw only a fast-running vehicle which crushed her husband at a little distance and did not see the accident herself. The husband died of a heart attack a day later. The wife's evidence can be taken of what her husband told her after the accident. It is relevant and admissible as res gestae. Then we have another problem, that is A sues B for libel, that is defamation, contained in a letter forming a part of the correspondence. Are the facts of the letters between the parties not containing the defamatory statement relating to the objects subject out of which the libel arose relevant under section 6. So here the concerned facts are relevant under illustration C of section 6. The facts are relevant though they are not in issue if they are so connected with the fact in issue as to form the part of the same transaction. So the facts are relevant although they are not in issue if they are so connected with the fact in issue as to form the part of the same transaction. Now another problem, are the remarks of the spectators made at the time when A bet B in their presence relevant? So here section 6 of the Evidence Act 1872 that speaks of a doctrine of res gestae is applicable. As per section 6, a fact is relevant even if it is not in issue but so connected with the fact in issue as to form the part of the same transaction. In this problem, remarks made by the spectator while A bet B in their presence is though not fact in issue yet is connected with the fact in issue as to form the part of a same transaction and thus relevant under section 6. The next problem, B was charged with murder of C. A had seen B going towards the house of C. Immediately after he heard C groaning when he went to C, he was told by C that B had shot him. Is the testimony of A admissible against B? Answer with the reason. So here it is similar to the illustration of A under section 6 of Evidence Act 1872. In this problem, B was charged with murder of C. A had seen B going towards the house of C. Immediately after he heard C groaning and when A went to C, he was told by C that B had shot him are relevant and admissible facts because under illustration A, whatever was said or done by the accused person, the victim or bystanders so shortly before or after the incident as to form the part of the same transaction are relevant. Now, next problem. A makes a statement to her husband immediately after she was raped by B. Is this statement admissible as corroborative evidence? So here section 6 and section 8 of the Evidence Act 1872 is applied. The statement made by B to her husband immediately after being raped is relevant under section 8 of the Evidence Act. The statement would have been relevant under section 157 of the Evidence Act as corroborative evidence if it was not made by her to her husband immediately after her rape. Now the next problem. The question is whether A murdered B during the course of a struggle. Marks on the ground produced by the struggle at the place of the occurrence is relevant fact under which section of the Evidence Act? Give reasons for your answer. So here the relevant section is section 7. So here section 7 deals with the circumstances that happens before and after the crime, and here section 7 is made applicable. Now A tried for murder of B are the facts that B knew that A had murdered C and that B had tried to extort money from A by threatening to make his knowledge public relevant. So once again, illustration A of section 8 of the Evidence Act 1872 is applied. The concerned facts are relevant under section 8. According to section 8, a fact which shows or constitutes motive for any fact in issue or relevant fact is relevant. B had knowledge that A had murdered C and B had tried to extort money from A by threatening to make his knowledge public are relevant under section 8 of as showing motive of A for the murder of B. The next problem, A tried for the murder of B by poison. Is the fact that before the death of B, A procured poison similar to that which was administered to B relevant? So that is illustration C of section 8 of Evidence Act 1872. The fact of procuring poison is relevant under section 8 as showing preparation. A fact which shows or constitutes preparation for any fact in issue or relevant fact is relevant. The act of A for procuring poison similar to that which was administered to B shows the act for preparation by A to murder B. A next problem, that is A is tried for murder of B. are the facts that A murdered C, that B knew that A had murdered C, and that B had tried to extort money from A by threatening to make his knowledge public are relevant. Decide and give reasons for your answers. So this question we already discussed. Section 8 of the Evidence Act 1872 is applied. Evidence of motive is not sufficient by itself to lead to conviction, nor absence of it to discredit other evidence. When there is a clear evidence that a person has committed an offense, the motive becomes irrelevant. A murder case based on the direct evidence does not become weak just because of the want of a motive. Motive is a moving power which impels one to do an act. Evidence of motive is always relevant. The evidence of motive assumes special importance when the whole case is built upon circumstantial evidence. On the murder of the old widow possessed of wealth, the fact that the accused was to inherit her fortunes on her death was held to be relevant, as it showed that the accused had a motive to dispose her of, and that was held in Tarseem Kumar versus Delhi Administration, AIR 1994. Tarseem Kumar versus Delhi Administration. Now, once an offense has been committed, the evidence of preparation becomes most important, for the crime must have been committed by the man who was preparing for it. Now, the fact of the problem are identical with illustration A of section 8. The knowledge of B regarding the murder of C and C by A and attempt by B to extort money from A by threatening to make his knowledge public are relevant fact because these facts show the motive for the murder of B. The motive is not to pay extortion amount, and also the fact of murder of C by A not being made public by B. Now, next problem. A woman was raped on 10th August 2017 when her husband was away. The husband came home on 12th August 2017 and then she told him that she had been raped. Discuss the relevancy and admissibility of her statement in the evidence. So that is illustration J of section 8 of Evidence Act 1872. In this problem, A was raped on 10th August 2017 when her husband was away. The husband came home on 12th August 2017 and then she told that she had been raped. This is relevant and admissible in evidence as a conduct of the party in a proceeding against whom the offence is subject matter of the proceeding. It is naturally that it would be husband or any other family member whom she meet first that she will complain. In the illustration J, the words shortly after the alleged rape, she made a complaint depends on the circumstance of the case. Since the husband was not at home and when he returned home, she made a complaint will not render the complaint inadmissible in evidence merely because it was made 2 days after the incident. Now, next problem. A woman whose throat had been cut by some sharp-edged weapon indicated by gestures before her death that B was the person who had cut her throat. Is the statement of A made by gestures admissible as evidence against B? So section 8 of the Evidence Act 1872 is applied here, and the relevant case law is Queen Empress versus Abdullah 1885. In this case, the accused cut the throat of a girl with a razor. She was taken to a hospital where attempts were made to know from her the name of the accused. She answered by sign of her hand. When the accused's name was mentioned, she made an affirmative sign. Section 8 was not applicable. So as to attract Section 8, the conduct must be influenced directly by the facts in issue or relevant fact and not by the interposition of the words spoken by the third person. Now, the sign of the hand were not influenced by the facts but by the question asked. The evidence was, however, relevant as a dying declaration. So it was not admissible, made admissible under Section 8 but made admissible under Section 32 subclause 1, that is with respect to dying declaration. It was held by full bench of Allahabad High Court. If the injured person is unable to speak, he can make dying declaration by sign and gestures in response to the question. Now, another problem, that is the question is whether A robbed B. The fact that after B was robbed, C said in A's presence, the police are coming to look for the man who robbed B, and that immediately afterwards A ran away. So this is again an illustration that was given under section 8 of Evidence Act, that is illustration F. Now, running away of A immediately after the statement of C in A's presence that the police were coming to look for the man who robbed B is relevant because it shows the conduct of A subsequent to the crime and also the statement affecting the conduct of A, which is itself relevant under explanation 2 of section 8. Explanation 2 of section 8. Now the next problem is A is prosecutor for murder of B. Is the fact that A, when told that the police was looking for murderer of B, started running away relevant? So that is exactly same as what we discussed right now. Section 8 of Evidence Act and illustration F is applicable. It is relevant with respect to conduct after the crime, and explanation 2 of section 8 is applied. Now the next question. The question is whether A had to repay the debts of 2000 rupees to B. Evidence is given of the fact that A asked C to lend him 500 rupees and D told C in presence of A, do not trust A because he had not yet repaid 2000 to B, and A left the place without making any reply, whether it is a relevant fact. By section 8 of Evidence Act 1872, the facts of this problem are similar to the illustration G of this section, that is section 8 of Evidence Act. In this problem, the question is whether A had to pay rupees 2000 as debt to B. By the evidence that A asked C to lend him 500 and D told C in presence of A not to trust A because A had not yet repaid 2000 rupees to B and A left the place without making any reply, the conduct of A in leaving the place when D told C not to trust A is relevant. The statement made by D affects the conduct of A and the conduct itself relevant under explanation 2 of section 8. So explanation 2 of section 8 is when the conduct of any person is relevant, any statement made to him or in his presence and hearing which affects such conduct is relevant. So the next problem. A is tried for the murder of B. Evidence is offered at the trial to show that A absconded after receiving a letter warning him that the inquiry for the murder was being made. Discuss the relevancy of the aforesaid fact. Now that is illustration H of section 8, which deals with the motive, preparation and conduct. Now, according to explanation 2 of section 8, when the conduct of any person is relevant, any statement made to him which affects such conduct is also relevant. Now, A absconded after receiving a letter warning him that inquiry for the murder was being made is relevant as showing the subsequent conduct as well as affecting such conduct of A when the statement through letter was made to him. The fact are relevant as showing that the subsequent conduct of A shows guilt feeling. Now the next problem. At the trial of A for the murder of her husband B by administering arsenic to him, evidence is offered to show that A and B used to have frequent quarrels. Discuss fully whether the evidence offered is admissible. Now section 8 of the Evidence Act is the relevant section here. The evidence offered is admissible because that shows the motive of why the wife should poison the husband. In this problem, the factual issue is whether A murdered B or not. The frequent quarrels between A and B constitutes the motive for the murder of B by A and it is relevant. The next problem is A is tried for the murder of B. Is the fact that A purchased the air ticket for a distant country just after the murder of B relevant? So that is again section 8 of Evidence Act 1872. The conduct that can be previous or subsequent of any party to any proceeding regarding such proceeding or regarding any fact in issue therein or relevant thereto is relevant if such conduct influences or is influenced by any fact in issue or relevant fact. Now the next problem. A is tried for the murder of B by poisoning. Is the fact that before the death of B, A procured poison similar to that which was administered to B relevant? Yes, it is relevant by because it was preparation for the murder of the other party of the deceased and it is brought under section 8. Now the next problem. The question is whether A robbed B. Does the fact that shortly before the robbery, B went to a shop with money in his possession and showed it to a third person relevant? So that is also a creation of motive and that can also be brought under section 8 of the Evidence Act 1872. Now the next problem. A is accused of a crime. Prosecution has shown that he absconded from his home immediately after the incident. Can A prove that he had an urgent work at that time? So if A can prove that he had an urgent work at that time, then this will not be a relevant fact under section 8. He can use it to his defense that this act doesn't show any guilt feeling or any of his any issue with the crime, or he doesn't have any part in the crime. I'm sorry, it doesn't show that he doesn't have any part in the crime. So section 8 gives relevance to the motive, preparation and conduct, and the conduct can be previous or subsequent. So by general rule, when he absconds, the court will take a adverse presumption that the person has a guilty feel, and that's the reason why he has absconded. But if we can prove that he had an urgent work and that is the reason he absconded, that is also relevant. Both the incidents are relevant, but the court will not presume any adverse presumption against that party. So that is the relevance here. So by explanation 2 of section 8, any conduct that can be before, previous or subsequent, that will, if the conduct is relevant, the incidents related to it, what has been said or done related to such conduct, will also become relevant. Now the next problem, the question is whether A robbed B. Okay, that is what we just discussed. No, the question is whether A robbed B. Does the fact that shortly before the robbery B went to a fair with money in his possession and showed it to a third person relevant? Yes, it is relevant for the motive, that is under section 8. Now the next problem, A is accused of a crime. It is shown that soon after the crime he is absconding his place. If this fact is relevant, the fact is relevant, and the fact that why he went is also relevant, that is under section 8, explanation 2 of section 8. The next problem is A is tried for murder of B by poison. Before the death of B, A procured poison similar to that which was administered to B. Explain the relevancy of the fact. This comes under preparation under section 8 of Evidence Act. Now the next problem is A used B for inducing C to breach a contract of service made by him with A. C, on leaving A's service, says to A, I am leaving you because B had made me a better offer. Whether this statement of C is relevant? Yes, it is relevant. Section 9 of the Evidence Act 1872 will be applied here, and it is also discussed in the illustration D of section 9, according to which A used B for inducing C to break a contract of service made by him with A. C, on leaving A's service, says to A, I am leaving you because B had made a better offer. The statement is relevant fact as explanatory of C's conduct, which is relevant as a fact and issue. In the present problem, if A used B for inducing C to breach a contract of service made by him with A, C, on leaving A's service says to A, I am leaving you because B has made me a better offer. This statement will be relevant fact because it is explanatory to C, explanatory to C's conduct, which is relevant as a fact and issue. So section 9 deals with anything that is any fact that introduces or explains the conduct or any other relevant fact with respect to fact and issue. Now the next problem, A, an accused of theft, is seen to be given the stolen property to B, who is seen to give it to A's wife. B says he delivers it. A says you to hide this. Whether B's statement is relevant? It is relevant under section 9 of the Evidence Act because those explain the facts related to fact and issue, and it is discussed in illustration E of section 9. Now the next problem, A is tried for rioting and it is proved that he was marching at the head of the mob. The prosecution wanted to prove that the mob was shouting. Is it relevant? Section 9 of the Evidence Act 1872, this section says that those facts are relevant that are necessary to explain or introduce a fact and issue, or relevant fact or which supports or rebuts an inference suggested by a fact and issue, or relevant fact or which establish the identity of anything or person whose identity is relevant, or fix the time or place at which any fact in issue or relevant fact happened, or which shows the relation of parties by whom any such fact was transacted, insofar as they are necessary for that purpose. The explanatory evidence is not relevant in itself if considered separately and alone. From other evidence, it would not amount to anything. Where a person is tried for leading certain people to a riot by marching at the head of the dime, the cries of the mob may be given in evidence being explanatory of the nature of the transaction. And this is seen in the case law of R versus Lord George Gordon. R versus Lord George Gordon. The accused was tried for a riot and was proved to have marched at the head of the mob. The evidence of the cries of the mob was received as the cries were relevant because they explained the nature of the transaction as to why the accused was so marching. The facts of this problem are similar to illustration B of the act. The shouts of the mob are relevant, being explanatory in nature, and prosecution can prove it. So that is with the first part of Q&A with respect to Evidence Act. We have plenty more problems for discussion, and that will be carried out in the following parts. Thank you everyone for listening. Stay tuned. Please like, comment and subscribe. Thank you everyone. Have a nice day.